All right, people, welcome to Jumbo IS and welcome to lecture number 6 from Polity in this lecture series called Prelims Powerplay 2026. Through this lecture series, we will cover the entire syllabus for UPSC Prelims 2026. We will revise everything. Okay. Now, we will revise current affairs as well as static topics. The thing is that if you really want this lecture series to be advantageous for you, you have to follow these 4 steps. Step number 1, watch the lecture on time, because little by little we will revise everything. Till your prelims examination, everything would be revised. So do not miss out on any lecture. Lectures would drop on YouTube every day at 9 p.m. Then step number 2, along with these lectures, we would provide you with notes. Now, those notes would also contain some extra information. So memorize those notes. It will be really helpful for prelims. Then step number 3, well, we have enrolled you in our WhatsApp groups. Those WhatsApp groups are specifically created for your doubts. So as soon as a doubt occurs to you, ask that doubt. And step number 4, we all know that without giving adequate tests, we cannot clear prelims examination. Therefore, along with this lecture series, you are also getting access to our test series for prelims. It contains an exhaustive list of tests. Please give those tests on time. Do not miss out on any test. Okay, so follow these 4 steps. Now, as far as step number 1 is concerned, you don't have to worry about anything because lectures will drop on YouTube every day at 9 p.m. But for notes, for WhatsApp groups, and for the test series, you would have to register on our app or on our website. The links to both are given in the comment section below. Okay, you just have to click on one of these links and you can register for this lecture series and ensure success in your prelims examination this time around. Join Prelims Powerplay. It will be really beneficial for you guys. All right then, enough of the introduction. Let's straight away jump into today's lecture, and our today's topic of discussion is anti-defection and speaker. Because in July 2025, Supreme Court gave a landmark judgment with respect to anti-defection law and the powers, role and responsibilities of the speaker, the presiding officer. Basically, Supreme Court was hearing a case with respect to the conduct of Telangana Assembly Speaker. Now, through this judgment, Supreme Court has basically given us certain points with respect to what are the powers of speaker in case of deciding matters related to anti-defection. By the way, we all are familiar with anti-defection, right? But nonetheless, we will cover this entire topic of anti-defection, the static topic of anti-defection, as well as we'll talk about this judgment. Okay, so that whether it's current affairs or the static topic of anti-defection is covered for you. You don't have to worry about any MCQ that can be asked from this particular topic. Okay, so without further delay, without further ado, let's straight away jump into the lecture. So Polity, lecture number 6, speaker and anti-defection. Now, what is basically anti-defection? You all know that we follow parliamentary form of government, right? It is parliamentary form of government where different political parties fight elections, and on the ticket of different political parties, well, electors, MLAs or MPs, they fight elections and they get elected. Now, based on the number of electors a particular party has, based on their number, well, they form the government. But sometimes because of horse trading or any other reason, and those reasons are most of the times not good, some legislators defect from one political party to another political party, right? Now, this causes instability because this would lead to fall of any government formed by a political party. Okay, by giving the greed for money, some legislators might shift allegiances. This causes political instability, and we do not want political instability in our government because we want to take India forward. Now, this realization came way back in India's early independent history. Okay, so therefore, this defection, this shifting of allegiances was banned. How was it banned? Well, it was banned that any legislator, any MP, MLA which shifts political parties will be disqualified as a legislator. So there was this disqualification provision, and this disqualification provision was added by amending the constitution. It was 52nd Constitutional Amendment Act. And through this 52nd Constitutional Amendment Act, a schedule was also added in the constitution, which is known as 10th schedule. So 10th schedule basically deals with anti-defection. Okay, so let's read certain introductory facts about anti-defection. So anti-defection law enshrined in 10th schedule via 52nd Amendment Act 1985 curbs political defections to uphold party discipline and voter mandate. Party discipline part, you understand. But voter mandate, look, most of the times voters vote for a particular MP or MLA because he or she belongs to a particular party. So voter wants to vote for BJP or Congress, for example. They voted for Congress. That MLA or MP got elected, but after getting elected, he shifted his political party to BJP. Now, this is basically, well, you are somehow letting your voters down. Yes, this is not good. Voters would feel cheated. So, to protect voters' mandate, also anti defection is important. Okay, now, whenever anti defection cases occur, okay, this would lead to disqualification of those members of Legislative Assembly or Parliament. But wherever there is a defection, the case goes to the presiding officer of that house. If it's Parliament, then it's Speaker, Lok Sabha, then it's Speaker, Rajya Sabha Chairman, and if it's a state legislative assembly, then the Speaker of that state legislative assembly. The final call on disqualification of a defected MLA or MP lies with the presiding officer. And our constitution is very clear on this. The presiding officer acts as the sole adjudicator under para 6 of 10th schedule, okay, deciding the disqualification petitions quasi-judicially. Basically, when the speaker is deciding on this disqualification matter under 10th schedule, he is acting as a judicial body or quasi-judicial body. Hence, we use the term quasi-judicial, which means almost judicial. Okay. So, para 6 of 10th schedule gives the authority to the speaker or the presiding officer to act as the sole adjudicator. Make sense? Simple? Yes. Now, how did this thing came about? What is the historical evolution of this entire matter? So, it was earlier known as Ayaram Gayaram syndrome, which means the legislator came to one party and then within a short span of time went back to another party, shifting parties very quickly. This was called Ayaram Gayaram syndrome. Now, defections surged post 1967 elections, prompting reports like Chahal Committee was formed, YB Chavan Committee, Sarkaria Commission formed. All these three bodies, these committees and commissions, well, they recommended that we need anti-defection law. And listening to these committees and commissions, well, 52nd Constitutional Amendment Act was passed, which inserted 10th schedule, so as to maintain, again, party discipline. Remember these keywords, party discipline, these were the objectives, okay, and voters' mandate. Pardon my handwriting, but I hope you're understanding what I'm writing right now, okay. So, party discipline and voters' mandate. Now, all important provisions with respect to anti-defection law in India are given in 10th schedule of the Constitution. So, let's investigate thoroughly 10th schedule of the Constitution. So, what are the important provisions written in 10th schedule of the Constitution? Okay. Now, the most important provision is paragraph 2 of 10th schedule. Okay. This paragraph 2 lists down what amounts to defection. Okay. So, these are the grounds which amount to defection, and based on that, the MP MLA can be disqualified. Okay. So, remember, if there is a MCQ, it says that the grounds for defection are mentioned in para 6 of the 10th schedule. That would be wrong. It's in para 2. Make sense? Now, what are those grounds? If an MP MLA voluntarily gives up party membership, he or she voluntarily resigns from their party, this amounts to defection. Then, well, there is voting in the house and a particular party or the chief of that party said that you would vote yes, but the MP MLA of that party voted no. Okay, so votes abstains contrary to party whip. If party has made an announcement that you will vote in this direction and you took a completely opposite direction, that also amounts to defection. Okay, without prior permission. And if you want to vote contrary or abstain from voting, basically you are absent on that day when this crucial voting would take place. So if you want to do that, then take prior permission of the party, condonable within 15 days, okay, 15 days beforehand. If not, if no permission is taken, defection. Then, if a particular MP or MLA does not belong to any political party, he's independent, but just after the elections, he joins a particular party. This also amounts to or violation of voters' mandate. because the voters voted for this candidate because he was independent. But as soon as he got elected, he joined BJP or Congress or any other party. So this also amounts to defection. And in our house, in both Lok Sabha and Rajya Sabha, in Lok Sabha there were Anglo-Indians, but in Rajya Sabha there are now nominated members as well. Now, if you did not fight elections, but you were nominated to Rajya Sabha, after nominations, okay, you have 6 months to choose your political party. If post 6 months you choose a political party, that also amounts to defection. Okay, so all these nominated members who are nominated on the basis of their service to the nation, art, culture, social, everything, you all know about the grounds for nominations. If these people have till 6 months, after 6 months they can't join any political party. Okay, so this is ground number 4. Then there are other important paras to 10th schedule. Okay, other provisions of 10th schedule. Para 3, no disqualification of 2 third party members merge. Okay, merger is not considered disqualification. So let's suppose there was this party called Shiv Sena, okay, and there was BJP. So Shiv Sena had, let's suppose, 9 MLAs. Okay, BJP had, let's suppose, 100 MLAs. Now, if Shiv Sena MLAs join BJP, that is defection. But if 2/3 of the Shiv Sena MLAs, that is 6 members, okay, they merge with BJP, that would be considered valid merger, and they won't be disqualified based on defections. Okay, so minimum 2 third party members decide to merge with another political party, that is permissible. Then para 4, presiding officers decides on petition. Para 4 lists down what are the rules and regulations with respect to filing a petition with the speaker or the chairman. Para 6, very important, speaker or chairman decision subject to judicial review. Okay, so speaker is the sole adjudicator. This is given in para 6. But there was a para 7 as well in 10th schedule. And do you know what this para 7 was? This para 7 said that the decision given by the speaker or the chairman was final and it was not subject to judicial review. This was final, nobody could question it. But we all know, generally speakers or presiding officers are mostly from the ruling party. Naturally, they can have some bias. Okay, therefore, a petition was filed in the Supreme Court in the landmark Kihoto Holohan case in 1992, and the Supreme Court in this case said that judicial review is part of basic structure of the Constitution, and basically not allowing judicial review in this case would be violation of basic structure. So para 7 was struck down, which said that the decision of speaker is not subject to judicial review. This was struck down. Supreme Court said it is subject to judicial review. Okay, and para 8, rules for procedures framed by presiding officers. Presiding officer can make rules with respect to how an application would be filed for defection and all these rules. Okay, so these are some key paras. Now, some changes were made to 10th schedule through another amendment to the Constitution. Okay, and that was the landmark 91st Constitutional Amendment Act of 2002-3. Now, what did 91st Constitutional Amendment Act do? Okay, so first of all, it did something which was not related to anti-defection. Okay, earlier what used to happen was that ruling party, there was no limit on how many ministers would come from the ruling party. So through 91st Constitutional Amendment Act, well, we put a cap on the number of ministers from ruling party. Okay, the total number of ministers, including Prime Minister and Chief Minister, cannot exceed 15% of the total strength of the House. It cannot be more than 15%. Otherwise, you'll keep on making ministers to oblige your strong party members. So this limit was put in place. Remember this. Then, what used to happen was, let's suppose a Shiv Sena MP or MLA resigned from Shiv Sena and joined BJP. Now, it was natural for them to be disqualified. Okay, but the BJP gave this person an offer. If you'll resign from Shiv Sena and join BJP, we will offer you ministership. Now, in our constitution, you know this, that a non-member can also be appointed as minister. He's not member of the House, but he can be appointed as a minister, provided he fights elections and get elected to either Lok Sabha or Rajya Sabha within 6 months. But for 6 months, he or she can stay in power in BJP. Yes, this provision was there. Make sense? In 6 months, he would either fight elections for Lok Sabha or BJP government from any state would nominate him for Rajya Sabha and he would stay in power. That was the case. This was a way out from anti-defection. But this was also banned in 91st Constitutional Amendment Act. So disqualification from ministry members disqualified under anti-defection. So you cannot make a disqualified MP MLA a minister. This was done. Then split provision deleted. Earlier what used to happen was that if 1/3 members of Shiv Sena said that we would create a separate party, that was considered as split within the party, provided you have the support of 1/3 members, and that was considered valid, no anti-defection. This provision was deleted, and the threshold was increased to 2/3. You require minimum support of 2/3 members. That's what happened with Shiv Sena as well. And merger provision was strengthened. A merger is now only valid if at least 2/3 of the members of the legislative party agree to merge with another party. Okay, so first, split is banned. Okay, split is not allowed. There will be defection. And if you want to merge with another political party, you require 2/3 support. Make sense? Okay, so these are the provisions, static provisions with respect to anti-defection. That's all you need to remember. These are the provisions that you need to remember. Remember the paras, remember 91st Constitutional Amendment Act, and remember para number 2, very important. And also remember that para 7 was deleted by Kyoto Holohan case. Now, from Kyoto Holohan case, let's talk about something else also. And this is the landmark cases with respect to anti-defection. Okay, so here is a table with respect to landmark cases. Okay, so go through this table. Okay, the most important case, though just give a cursory reading to all the other cases, the most important case was Kyoto Holohan case in 1992. It basically said that, well, para 7, Kyoto Holohan deleted para 7, that judicial review is part of basic structure. Next, Kyoto Holohan also said that speaker, while deciding on anti-defection, acts like a tribunal, and tribunals are subject to judicial review of the Supreme Court. Therefore, speaker's decisions are also subject to judicial review. So this association with a tribunal allowed Supreme Court to say that it is subject to judicial review. This was the landmark case. Give a cursory reading to others also, but this is the most important one. All right. And now let's talk about the recent landmark judgment. Okay. And that was Paddy Kaushik Reddy versus State of Telangana. Okay. The Supreme Court gave a judgment on this case in July 2025. Okay. Let me give you a brief background what happened. So elections happened to the Assembly of Telangana. Okay. Now there were 10 members, MLAs, who got elected from BRS. Okay. But after getting elected, they joined Congress. Okay. So these 10 members from BRS, they shifted party allegiances to Congress. Now Congress won the election, so it was the ruling party. Now, as you all know, that speaker is generally from the ruling party. Right? So speaker was from Congress. Now these 10 MLAs who defected, naturally they should be disqualified, and they would be disqualified by the speaker. Yes. So legally speaking, speaker should disqualify them. But speaker has some bias towards Congress party. Therefore, speaker took advantage of a loophole. And what was that loophole? The loophole was that 10th schedule does not mention any timeline within which speaker has to take a decision. There is no time limit mentioned in 10th schedule. Because there is no time limit mentioned, speaker kept the decision pending, and these 10 members who joined Congress remained there. Okay. Therefore, BRS naturally approached Telangana High Court. Now, Telangana High Court gave a judgment which was not that supportive towards the cause of BRS. Therefore, they appealed to the Supreme Court, and Supreme Court basically said that the decision is subject to judicial review as decided by Kyoto Holohan case, and therefore we are directing the speaker to decide on the matter within 3 months. And they also said that time limits should be placed on speaker. Okay, so this was the landmark judgment. Now, timelines or time limits are included in the decision taken by the speaker. This was the landmark part of this judgment. Supreme Court introduced timelines. Okay. So Padi Kaushik Reddy versus State of Telangana is a landmark Supreme Court judgment addressing delays in anti-defection disqualification proceedings under 10th schedule. It was delivered by these judges. SC set aside High Court Division Bench, Telangana High Court Division Bench order holding speaker under para 6 10th schedule acts as a tribunal. And this tribunal association was made in Kihoto Holohan case. And as per Kihoto Holohan case, well, para 7 was deleted. Therefore, speaker is not immune from judicial review, which is generally given to speaker under Article 122 of the Constitution and 212 to the state speaker. Okay, Article 122, 212 give immunity to speaker and state speaker from judicial review. This immunity does not apply to anti-defection because of Kihoto Holohan. Therefore, it directed conclusion of proceedings against all 10 MLAs within 3 months. So this was the landmark judgment. All right. And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. But it would add more value if you follow these 4 steps. Watch the lecture on time, memorize the notes, ask your doubts, and be regular with the test as soon as it comes to you. Okay? The schedule is already known to you. So with that, we'll conclude today's session. Thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I shall take your leave with the promise of seeing you again with another topic in this lecture series called Prelims Powerplay. Thank you, everyone.